Mr. President. My colleagues, my own is just at the point of caution of the Senate. The executive that comes to this room, when they are here, we used to ask the female counterparts to take a bow and go. Why are we doing a different thing in the floor of the Senate? Where she deserves to take a bow and go. So, because when the executives are here, we ask the women to take a bow and go. Why? For a woman, no, I'm coming, please. For a person have gone to this level, she has served the country, and she has answered all the questions. And you people are still putting your hands up to continue keeping her. I mean, it does not make sense, my colleagues. I only want her to explain to me just one question. My name is my question is commendation. That a woman of this level has gone this far. My motion, I'm putting a motion on the floor of the Senate. I'm putting a motion on the floor of the Senate. Mr. President, I'm putting a motion on the floor of the Senate.
We will not entertain motions when we are doing this kind of important screening.
No, it's very important, but we have contradicted our rules.
I want to thank you for your contribution. I want to thank you.
We have contradicted our rules.
I want to thank you.
Our rules is that I'm moving a motion that she should take a bow and go.
Distinguished Senator Orji Uzor Kalu, knowing that what we are doing here is very serious, and also knowing that the entire Nigerians are glued to their television to listen to the incoming Chief Justice of Nigeria, and knowing that all the embassies in Nigeria are listening to her, and knowing that the global community is listening to her. I want to, is there anybody in support of that motion? Those in support say aye. Those against say nay. The nays have it. You are ruled out of order. Now, I must also correct you that we are not screening her as a woman. We are screening her as an incoming Chief Justice of Nigeria, substantive. And if you want to know, even in within the bar, there is no woman. I addressed the Nigerian Bar Association recently, and I said, my dear brothers, my colleagues, my brothers and sisters, they all went mental. So finally I said, okay, I've withdrawn the sisters, my dear colleagues, and they now applauded, because when you are in this kind of position, there is nothing like woman. So there is no gender difference in the judiciary. So let me go to South. Distinguished Senator Ekong Samson.
Thank you, Mr. Chairman. Tributes for the nominee. The office is no doubt a very serious office. And I recall the words of Karu Esho, JSC as it then was, who said that the Supreme Court is a super court, and the justices of that court are superhuman beings. So the nominee is coming aboard at a very important time in this country. My question is on two major limbs. One, we talk so well about needs to broaden and enrich the access to justice. I would want to know respectfully, my Lord, if we confirm you, will you support the position that in our attempts to further enrich the bench, some members from the academia can be brought aboard to the superior bench, just as it was with Elias, just as it was with Toby. Two, we also share strongly from the passions about the need for the justice system to be run in such a way that substantial justice prevails over rules of technicalities, over issues of technicalities. As the Chief Justice of Nigeria, respectfully, how would you encourage the side of opinion that substantial justice at all times must prevail over undue technicalities? I was very impressed, my Lord, when you spoke about the Supreme Court as a policy court. That answers a lot of questions. On that limb, I would like to know, how would you, in broad terms, encourage the Supreme Court to reign as a court of policy, which will deepen the confidence of the public in that court and in the justice system in this country? Thank you.
Yeah, thank you. But you know, she is a court of law and also a court of policy. So they must also deal with issues of law as well as issues of policy. But the fundamental question you have asked is, my Lord, will you support the elevation of lawyers from the bar straight to the Supreme Court or straight to Court of Appeal without that senior legal practitioners, without passing through the High Courts, Magistrate Courts, or otherwise? I think that's the question you asked. Elevation of very senior practitioners, and also elevation of people from the academic, like Professor, that's the bar. I'm talking about moving people from the bar, whether they are in the academia or whether they are in strict legal practice. But the question is, many of them are agitating to be moved straight to the Supreme Court, boycotting the other courts. Would you support? Because you mentioned Justice Elias, and then you mentioned Nikki Toby. I don't know what happened in the case of Justice Nikki Toby, but I know that Justice Elias came from, I think, either from practice or whatever, straight to the Supreme Court. Am I right? And so that's the kind of thing you're talking about, that by merely practicing, that they have enough experience to be moved to the Supreme Court, to populate the Supreme Court without passing through the runs. So I think she got the question. She will be able to put it well. Distinguished, I'm in South. Distinguished Senator Adams Oshomole.
Aliu Oshomole. I represent the good people of Edo North from Edo State, where my Lord, the acting Chief Judge, did an NYC. Like everybody has said, sir, no one will look at this CV and want to ask questions. And I thought that for those who are in doubt, this training is not an act of favor or punishment. We just want to be enlightened as to have a window into the way in which the mind of the next Chief Justice of Nigeria works. So for Kalu, I needed to understand that we are not doing her any favor by saying, take a bow. In any case, that has been settled. I just want to ask one or two questions. You know, my Lord, when we complain of crowded court, the courts only adjudicate based on the judicial confined on it by Parliament. For example, when my case went to court as a governor or governorship dispute, the law then was that cases are terminated at the Court of Appeal. The National Assembly, in its wisdom, chose to remove that bar and said the cases must now terminate at the Supreme Court. So we can't overload a vehicle and then blame the driver for carrying overload. But there are a couple of issues that I believe many of us distinguished senators must be aware of. That depending on the party you belong, at the level of the state judiciaries, people tend to prefer, talking about forum shopping, to file cases before federal high court, particularly if it's a case in which you believe the state governor or the state government may have an interest. And how we deal with this, how the Chief Justice of the Federation can encourage judges in the states to show the same level of courage to pronounce where it's so discovered that a state government or a state interest, a state governor has crossed the red line, that people should feel able to go to a state high court and get justice. I don't want to rush to federal high court because of the fear that judges, in many cases at the state level, don't want to enter judgment that will be offensive to the state executive. That is recently in the state, and for obvious reasons, I won't mention the state. The National Judicial Council approved the appointment of new judges, which is in line with the Constitution. But the state governor in Benin decided, I didn't mention him, I mentioned a city. A state governor in Benin refused to swear in. Excuse me.
You are protected. You did not mention the state. You only mentioned Benin.
Thank you, Mr. President.
Benin is not a state.
That's right. So, as we speak, those judges were not sworn in, even though they have been cleared by the National Judicial Council. When I was a governor, sir, there was a case, a judgment against the state government. But because the governor has immunity, the judge decided to convict the Attorney General for contempt of court. So I'm like, if a state governor disobeys a ruling of a superior court, and because the governor has immunity, there is nothing you can do, I would have expected that the Attorney General will be charged for contempt of court or showing disrespect to the National Judicial Council, so that the discretion we exercise should not be abused to the extent that all of the processes that the National Judicial Council goes through to select and approve and forward to the governor for ratification. I am sure, Mr. President, you approve many such recommendations, not necessarily because you like the persons, but in the wisdom of the National Judicial Council, they've cleared them. So I thought that there might be, we'd like to know whether a legislation is required or the Supreme Court, being a policy court, what it can do to help to curtail abuse of power at the level of the state. And lastly, there was this case of Mr. I don't know whether I should mention his name, a guy who was sentenced to 3 years in prison, up to the Court of Appeal. And the Supreme Court found that this was a criminal case that has to do with somebody who operated or officiated at the, I believe, MPA. He served all of the 3 years in prison. And then the Supreme Court found that he was wrongly convicted. The only benefit he's got is that he cannot now be referred to as a convict, but he suffered the punishment for 3 years. In such cases, where the lower court has misapplied the law, and a citizen has been sentenced to prison and served the whole of the 3 years, or even 5 years, is there a way in which the Supreme Court can order compensation for victims that suffer such humiliation for an act for which they were never guilty? And each time I see the guy on television, I wonder how he feels that he was in prison for 3 years, and the Supreme Court found that he was wrongly jailed, and yet he has suffered it and there are no compensation. I would have imagined that the court can award compensation, huge compensation, not the type that is not even enough to pay the cost of a senior advocate, but one that will also fairly compensate the victim for the period he spent in jail wrongly. Thank you, my Lord, and I also want to congratulate your family, because having seen that you serve in virtually all the judicial, north, south, east, west, that means that for most of the time, members of your family were alone. And so for you to accomplish this, I think members of your family deserve commendation as well. Thank you, Mr. President.
Shimole, we have to return back to the serious business of screening and asking pertinent questions. You need to know that even outside this climb, screening of this nature sometimes takes 42 days, 42 hours. In some jurisdictions, Chief Justice of Nigeria and even Justice of the Supreme Court designates are screened for up to 2 days. So, my Lord, it's not a waste of time. It is because Nigerians have a lot of questions that they want to ask, and they cannot ask those questions. We are their representatives. We are the ones that can ask. They want to hear from you as you are coming in, because after this, hardly will anybody see you, including my colleagues here. So this is the only time we can see you. So, and that's why almost everybody is struggling to ask one question or the other to hear your perspective to issues. And then we can now focus on the judiciary in the next 5 years, commencing from the reforms we are going to bring. Distinguished Senator Ningi.
Recognize me. My name is Senator Abdul Ningi, and I represent Bauchi, Central of Bauchi State. Let me join Mr. President in welcoming you and our Lordship to this very august chamber, and further congratulate you for this very, very special nomination. I recall seeing you in the confirmation of Justice Mohammed Tanko and Justice Ariola. You accompanied both of them. And one of the highlights of those two sessions was the issue that was raised by Senator Kwaka, SAN, on the issue of the ex parte order and the assurances we had then received by their Lordship doing something about it. These ex parte orders, my Lord, has become a tsunami in Nigeria. And therefore, some of us begin to wonder, how easy are these orders assessed? I can tell you straight that 6 years ago, Your Lordship, I had the opportunity of visiting a political friend in his office, and he opened his box and brought 5 ex parte orders in advance. Ex parte orders in advance. I'm from a competent court of jurisdiction in this country. And it makes me wonder how that is possible. And you could see within the last, by the time I met him, he was using these ex parte orders. All they were doing was to fill in the gap, fill in the dates. And he has assessed these ex parte orders in anticipation of possible problems by political opponents. And believe me, my Lordship, those orders succeeded at the end of the day. Now, the question that I would like to ask you, is the hand of the judiciary tight in the possibility of not making out sanction? Or do you need an intervention of legislation in making sure that such irresponsibility is actually made by a law of the National Assembly, making sure that it's criminalized? What's your opinion about it? I know, as a fact, you made mention of the necessity of this ex parte order, but you can see clearly it doesn't work in this country. People have these orders left, right, and center. People are trying to block road of justice at every given time. And I want during your tenure, so that by the time the next justice is coming before the Senate, this question may not arise. But these two justices, they are sure that something will be done, and actually nothing serious is being done about this matter. Please, I want you to comment. Thank you.
Senator Kombowe Friday Benson, representing Bayelsa Central Senatorial District. Mr. President, sometime on the 10th of May 2016, while addressing an audience, the Prime Minister of the United Kingdom made a very open declaration about Nigeria and Nigerians. That Nigerians are fantastically corrupt, distinguishing nobody, excluding nobody. The statement was so clear that Nigerians and Afghanistan, these two countries are the most corrupt countries in the whole world. And here we are. Sir, I want our very distinguished acting Chief Justice of the Federation to help us to explain those who David Cameron were actually referring to. Are they here? Which of them are the corrupt Nigerians? Are the senators corrupt? Is the judiciary corrupt? Which of them, which of the Nigerians is David Cameron referring to? Mr. President, sir, are we expecting a corruption-free moment and period of our reign in Nigeria? That is my question, sir.
Requirements of being a Chief Justice of Nigeria is to possess the power of witchcraft, to be able to interpret what a Prime Minister of United Kingdom meant with his statement. If you ask her now to explain what David Cameron meant, it means you are expecting her to possess some kind of spiritual powers that are different from her legal. About her competence and her experience in legal matters, not in fact, this brings me, my Lord, you can take the stage and join it and answer this other one. Should judicial officers allow social media reports to influence their decisions? Because you see sometimes in court, some people may take like 1,000, 2,000 people to bombard, and even right now, when I was a young lawyer and I appeared before you in 1989 in the magistrate court in Lagos, at that time, whenever there was a case in court, nobody was expected to comment on it. But today you see very celebrated senior advocates of Nigeria sitting down on television to comment on cases that are already before either the Court of Appeal or before the Supreme Court, in an attempt to influence the outcome of those cases. And then sometimes they sponsor social media rats to go attacking the judiciary and trying to influence in one way or the other decisions that are already before the before the courts. And sometimes they are even the counsels to those cases. So what will you do to stop judges from bothering themselves about the opinions of people on social media, about comments by prime ministers in other countries who themselves are not clean, about Nigeria? And then you focus on the law. You focus on decided cases. You focus on your conscience and things that will promote the rule of law in Nigeria, and ignore the outcry of sponsored social media. How will you make sure that their lordships across board ignore those things that will end up bringing injustice to Nigerians because of social media publications? My Lord, and then you may choose to ignore the
Distinguished Senator Ekong Samson, Akpabio South. I will address the issue of the need for substantial justice and whether there must be compliance with the issue of substantial justice and technicalities. Over the years, we have emphasized in our judgments about the need for courts to promote substantial justice over technicalities. However, I believe that sometimes there's a misconception on what constitutes technicalities, because we have rules, we have laws, we have precedents that we follow. And where a precedent is followed, it will not be correct to say that the court has enthroned technicality over substantial justice. All courts are admonished all the time to eschew technicalities, but it's not in every instance that matters are decided on technicalities. At the same time, where the court looks at the case before it and decides based on the facts and the application of the law. Sometimes the application of the law to the facts might appear to be rather technical, and this is why we also have the appellate courts who can correct errors where they are made. On the issue of elevation to the Supreme Court, I will crave your indulgence to leave that question for a different forum. Distinguished Senator Adams Oshomole from Edo North. You talked about the crowded courts docket and the position where at a point in time matters terminated at the Court of Appeal, later on moved to the Supreme Court, and then the difference between cases filed at the Federal High Court and cases filed at the State High Courts. What I would say is that it is the legislature that enacts the laws that confer jurisdiction on the courts. And therefore, anybody who has an option to go to either the Federal High Court or the State High Court is entitled to utilize that option. At the same time, where cases are decided, where it appears that a certain side is favored, the appellate procedure is there. And I think that is the only way we can curb it, unless there is clear evidence of bias or any inducement, corruption, or anything like that. But other than that, whatever decisions are given, the option is to go on appeal. And if you can satisfy the appellate court or the Supreme Court that the court concerned was swayed by other considerations, then the court will give whatever judgment is applicable in the circumstances. Now, on the appointment of new judges, the situation where judges have been recommended for appointment and they have not been sworn in that instance, the National Judicial Council has made its position very clear, and it is the National Judicial Council that gives the directive for who should be appointed. And once that is done, there is nothing more for the National Judicial Council to do. It is to the detriment of any state concerned if it is now working with a lower number of judges, and you have capable and already confirmed judges that are not being able to carry out their duties. It is not a matter that the Supreme Court can intervene in unless a matter is brought to the Supreme Court on that issue. The issue of compensation for a person who has served his time and found to be not guilty, can the Supreme Court order compensation? The Supreme Court can only decide on matters that are specifically brought before it and grant reliefs. And where there is no legislation that gives the court that power or that authority, there's nothing the court can do. At best, the court can just make an obiter comment on it, that this is a situation where, in ordinary course of things, this person ought to be compensated. But it's not for the Supreme Court to unilaterally make such an order, because everything we do has to be based on the jurisdiction that is conferred on the court. Distinguished Senator Abdul Ningi from Bauchi Central, you asked for assurances with regard to ex parte orders and an issue of ex parte orders prepared in advance, whether the hands of the judiciary is tied, and whether there should be legislation against the grant of ex parte orders. Now, the situation with ex parte orders, where it is, you see, in order to have the judiciary that we desire, we also need to be able to follow through on certain issues. If there's a situation where a judge is found to have ex parte orders prepared in advance, such a judge should be reported to the NJC and necessary action will be taken. It is not fair, even on the judiciary, when these allegations are made and nothing is done to substantiate them or to follow up on them. And we know that even when petitions are filed before the NJC, in some instances, you find that the petitioner comes back and withdraws the petition. So it is important for the NJC to be able to exercise its own powers, that these sort of matters are brought to its attention. And then the grant of ex parte order is discretionary, but there are guidelines. So where a judge is found to have ignored those guidelines, to have acted without due regard to proper process, or even the facts of the matter, then the necessary action will be taken once it is brought to the attention of the National Judicial Council. As I've mentioned, the code of conduct will be strictly enforced, and judges are admonished not to grant ex parte orders indiscriminately. So it's an act of misconduct. But at the same time, it would not be proper, in my humble opinion, to enact a law that does away entirely with ex parte orders, because they are necessary in certain circumstances. Distinguished Senator Ofowe from Bayelsa Central. Pardon? Ombowe, I beg your pardon. I want to believe that his question was rhetorical, and I have, I think, the permission of His Excellency to pass it over about whether who are those corrupt people. Then, Your Excellency, your question, should judicial officers allow social media to influence their decisions? Certainly not. We have taken an oath of office to carry out our responsibilities without fear of favor, affection, or ill will. So whatever is in social media definitely should not affect the way we make our decisions. However, it is true that there is a lot that goes on social media and other fora. And this is one of the aspects that contributes to the negative perception of the judiciary, because you have narratives out there that have no correlation to the facts that are before a particular court. And again, whether they are senior members of the bar or other members of the bar, there are procedures. A senior member of the bar who has earned the rank of silk, it's a privilege. It's not a right, and that privilege could be withdrawn if it is abused. So in any of these situations, the courts too will use their own powers. We do have powers where a matter is sub judice and somebody goes out in public on the television station, media, social media, to comment on those cases, because it does have a negative effect on the administration of justice, on how we handle our cases. Because when you then give a judgment, the way it is assessed is based on what has been in social media. But notwithstanding that, I would say that judges know the oath they have taken and will abide by that oath and not be influenced by social media. Thank you.
I know you were very political in the last thing that recently, very senior members of the bar, we all know them. They are fond of being on politics today. We were commenting on cases that are before either the Court of Appeal or the Supreme Court. And this wasn't the case in the past. We are saying under your tenure,
yes,
will there be a procedure where you bring some of them to justice? Because they ought not to, because their comments and their analysis tend to influence the final outcome of those cases. And in most instances tend to bring about injustice. Because they are not aware, they are not sayers of the facts that are before their lordships.
yes.
But they will go out there, instead of arguing the cases in the court, they will go and sit down on television and be arguing the cases on television. And for the junior lawyers, the younger ones who are coming up, they are now beginning to think that that is the norm. If under your tenure, any of those senior lawyers, or, brought to book to say you cannot, when the case is in court, it has become, the matter is down sub judice. So if the court can invite, or even the NJC can discipline a senior lawyer who is fond of sitting down to analyze cases that are yet to be decided upon on television, in social media and all that, I think it will serve as a deterrent and will also help to bring back the integrity of the judiciary and the judicial system that we are talking about. That's why we are saying, under you, will you tolerate it? Because if you sound a clear note of warning to Nigerians, the teaming lawyers across the country will be wary that there is a new sheriff in town and that people should stop using the social media, using televisions to try to influence judgments in their favor, instead of going to argue the matters in the court. They play to the gallery, and you'll see them rolling from side to side on television and all that. Sometimes it's for some of us who have been in practice for decades, I shudder in fear, and nobody calls them to order. So we are saying under you, will you take steps to bring sanity to bear by collaborating with the bar and ensuring that those people are disciplined and that matters that are sub judice should not be discussed on television, should not be discussed on pages of newspapers, should not be taken to social media, should not be taken for analysis on radios by very senior lawyers. If they lose the rank of senior advocates of Nigeria because of those actions, it will serve as deterrent to those who are.
Thank you, Your Excellency. As chairman of the Legal Practitioners Privileges Committee, we will ensure that those who should be disciplined, those who are in the habit of doing, speaking on social media, condemning the judiciary, commenting on cases that are sub judice, will not have anywhere to hide. They will be dealt with decisively. Thank you.
I believe Nigerians are very much reassured. The chambers is totally reassured of the fact that we are coming in with a very strict hand to ensure that justice is delivered to all and sundry, and not only to those who have access to social media to abuse the people the way they like. So I thank you for the questions you have answered, and it is my humble opinion that the leader of the Senate will make a statement for you to think about while we consider, we take cognizance of all the submissions you have made before us. Leader of the Senate.
This very important matter. I also want to once again thank my lords, the most senior judicial officers who have been a part of this proceeding. Mr. President, sitting as chair, we have come to the end of the first segment of this confirmation hearing. And what will be left in the second stage will be for us, as senators of the Federal Republic of Nigeria, to look into the various issues and be able to discuss and come to a final conclusion, except to add that we also have, as part of our prerequisite, we have all the necessary reports, the security clearance from the Department of State Security, the clearance from the Office of the Inspector General of Police, all alluding to the fact that we have before us a Nigerian who is clean in the eye of the law and who is deemed by the security agencies as a fit and proper person for us to consider to be Chief Justice of Nigeria. I also need to say, Mr. President, sitting as chair, that we do not have any petition before us as a parliament that would have inhibited us from further deliberating and taking a final decision on this matter. So having said all of this, Mr. President, sitting as chair, in order for us to be able to go to the next segment of this hearing, may I most humbly, at this point, move that we allow my Lord, the acting CJN, to take a bow at this point so that she can leave us for us to continue on the further legislative activities that we need to engage in for us to conclude this process. Once again, Mr. President, sitting as chair, I thank you and our distinguished colleagues.
Minority Leader sent a message that those who have further questions can do so in writing and pass through the chairman of the Senate Committee on Judiciary, Human Rights and Legal Matters, and our office will try to do justice to those things. Now, the motion for her to take a bow, so we go into other matters as we move, and seconded those who are in support that she has done justice to all the questions so far asked, and that she could take a bow and lead the team of very senior judicial officers out of the chambers and lead other strangers out of the hallowed chambers of the 10th Senate. Say aye. Those again say nay. The ayes have it. My Lord, we now take a bow.